From the Library of Congress in Washington, D.C.
Well, good afternoon and welcome to the Library of Congress. I'm Mary Jane Deeb, Chief of the African and Middle East Division here at the library, and I'm delighted to see you and to have such a wonderful turnout today. Donna Schieder, the acting law librarian, is away at the conference and has asked that we welcome you all on behalf of the Law Library. I also have to apologize, but Dr. Billington, who was looking very much forward to this program, has been detained and will not be able to join us. And I'm very sorry because he was really excited about this program. It is indeed a pleasure to co-sponsor the program with the Law Library, and it is important, it is a timely program that we are hosting today on the approach of the Halakah and the Sharia to contemporary legal issues. We are particularly grateful to Rabbi Shlomo Yaffe of the Institute of American and Talmudic Law, who agreed to come to the library from New York to be part of this exciting discussion. We're also very thankful to Professor Don Wallace, Chairman of the International Law Institute at Georgetown University, for taking the time from his very busy schedule to moderate this program. And last but not least, we at the library are proud to present one of our own, Dr. Issam Michael Saliba, the legal expert on Islamic and contemporary Arab law at the Law Library here at LC, whose idea it was to convene this program. What better place than to hold such a discussion than at the Library of Congress? It is at the Law Library and in the African and Middle Eastern Division, which I head, that scholars and researchers doing work on Islam and Judaism in all their manifestations come for primary resources on which to base their writings. And it is those writings that inform policymakers, students, the media, readers, and more generally, our patrons who come to the library to learn and to work on those societies in the Middle East and on their laws and the way their cultures affect the world around them. The library's collections of books, serials, journals, newspapers, manuscripts is in some 450 languages of the world today. Its foreign collections are larger than its American or English language collections. My division alone has materials in 35 different languages, including Arabic, Persian, Turkish, Uzbek, Kyrgyz, Azeri, Kurdish, Hebrew, Yiddish, Ladini, Armenian, Georgian, and so on, and Wolof and Swahili. And the Law Library, which since it was first founded in 1832 to provide Congress with reliable legal information, has grown to become the world's largest law library and holds a collection of over 2.65 million volumes, spanning the ages and covering virtually every jurisdiction in the world. So we are in a place where such discussions should be taking place more often. And I'm glad that today we have two major scholars who are ready to start on a program and a discussion which I hope will continue for much longer. But to introduce our moderator, who is himself a scholar in many, many fields of law, I would like to call upon Hong Sai Liu, Ms. Hong Sai Liu, who's Director of Legal Research at the Law Library.
Thank you all for being here today. And on behalf of our acting law librarian, Donna Schieder, I welcome you and I appreciate the opportunity to collaborate with our Middle East and North Africa division. It is my great honor and pleasure to introduce you our program moderator today, Professor Dan Wallace. He is one of these iconic legal figures whose career span seamlessly across public, private, and academic sectors, as well as the UN and international organizations. As many of you know, he is the chairman for the International Law Institute, which is based in Georgetown, and he serves on the faculty of Georgetown Law School. He served on many boards at different capacities, but for selfish reason, I would just highlight a few because I know those better than others. He serves on the Secretary of State Advisory Board on Private International Law, and he serves on the ABA section of International Law and Practice as a chair, and he's advisor to the ABA's International Legal Resource Center for the United Nations Development Program. And he is...
Which Hangzhou was the executive director.
And he served as a founding member of the Board of Governors for the International Development Law Organization, which is based in Rome as an intergovernmental organization. And I'm very happy to point out he also serves on the Advisory Council for the Law Library of Congress's own global legal information network. Very relevant to today's discussion, Professor Wallace has traveled widely and worked extensively in countries in North Africa and the Middle East. He was a Fulbright scholar in Turkey as early as in 1967. Does he look like he was there in 1967 as a fellow? And he served as a USAID regional legal advisor for the Middle East. Today, he's the chairman of the International Council for Middle East Studies. Among the many awards that Professor Wallace received during his career, I would just highlight one, and that is the Harry Jones Award, a very prestigious one from the Washington Foreign Law Society for his outstanding achievement in foreign and international law. And this is something I share as a secret, perhaps. On top of his distinguished career, Professor Wallace is a gentleman and a family man, who prizes his family more than anything else. And Professor Wallace would tell you that his lovely wife, Daphne, which I regard as a dear friend, is a true reason for all of his accomplishment. So it is with both respect and warmth I present to you Professor Wallace, the one and only. Thank you.
You know, I should be embarrassed. I plan to sit, but after that introduction, I feel I have to stand. I was whispering to the rabbi and to Issam, I don't like introductions, and theirs are going to be very short. Because President Billington is not here, James Billington, the librarian, will have a bit more time for this program. I'm going to say almost nothing, just one introductory remark. The title of this program, you'll notice, is The Approach of the Halakah and Sharia to Contemporary Legal Issues. I'm not a scholar of either Sharia or Halakah, but I know they are paths to correct living. In other words, both the Jewish law and the Islamic law, the Sharia, really they purport to be codes for all of life. I mention that because the legal tradition that we come from, the common law, ain't. It's a much narrower thing, and it may be that it limits our ability to appreciate the significance of Halakah and Sharia. I'm not sure. Well, we shall see. Our speakers are going to each have half an hour. I thought I'd ask Issam Saliba to speak first, since we've got Sharia, because in many ways Sharia is more familiar to some of us than Halakah, I'm sorry to say. And Rabbi Yaffe thinks that's all right. Let me say a word or two about each, and then I will sit down. I was saying I don't really believe in introductions, but I'm told by Mary Jane that we have to have some introductions for the purpose of recording the program. Issam is a colleague of mine on the board of the International Council for Middle East Studies, just mentioned. He's Lebanese by birth. He is the person in the law library, which is part of the Library of Congress, who specializes in Middle Eastern law, and I suppose includes the Maghreb and the North Africa, and Sharia itself. And he and I traveled to Damascus last year. He's a very solid fellow. I had not realized he advised Getty Oil and Hunt Oil in the Republic of the Yemen, but I'm supposed to say such things, and he did. And he lectures widely, so he's a very good man. I had not met Rabbi Shlomo Yaffe before, and I hate to read introductions. We already spent too much time on them, but I have to say a few things about him. He is the Dean of the Institute of American and Talmudic Law. He is a permanent scholar in residence to Shabbat at Harvard. He's a rabbi. And I think most, not impressive, but notable to me, he's the Jewish chaplain of the Hartford Fire Department. He, of course, has done rabbinical studies, and I think I'm going to leave it at that. And each of them can say something about themselves if they wish as they speak. So we'll start with Issam for half an hour, then the rabbi for half an hour. I'm fairly strict. I have these little cards that say 5210, and if needs be, I'll use them because I want to leave some time for the discussion afterwards. Thank you. Issam.
Thank you very much, Don, for this brief introduction. I am very pleased to be a part of this program and to discuss the approach of Sharia to contemporary legal issues. Sharia, in its Islamic context, can be defined as, first, the divine revelation transmitted by the Prophet Muhammad to the whole of humanity. Two, as the road leading the believers into the path of eternal salvation. And three, as the code of conduct regulating all aspects of human behaviors. Under the third definition, law as we understand the word in the West, meaning the legal rules enforceable by the state, is a part of the Sharia. Muslim scholars, realizing the need of the believers to follow the law and comply with its dictates, acted on their own initiative, independent from and sometimes in confrontation with the state, to study the Sharia, comprehend its content, and elaborate its law. The work of these scholars in this domain evolved into a specialized discipline of study called ilm al-fiqh, or science of understanding. Fiqh may be defined as the study of the practical rules of Sharia. Now, this definition of fiqh excludes doctrinal rules of faith, such as the belief in God, in His prophets, in the Day of Judgment, which are subject to a separate discipline of study called ilm al-kalam, or science of theology. Muslim scholars compared fiqh to a tree, having few roots and many branches, and divided its study into the study of the roots, or usul, and the study of the branches, or furu'. The study of usul is concerned with the methodology and guiding principles pursuant to which the legal rules are elaborated. The study of furu' is concerned with the elaboration of these very rules themselves. The furu', or the branches of the law, are divided into two major components, ibadat and mu'amalat. Ibadat mean acts of worship, such as prayers, fasting, and pilgrimage. The rules of ibadat are mandatory, but their enforcement is left to the will of the believers, not to the authority of the state. These rules cannot, therefore, be described as rules of law, in the same meaning we use the term law in the West. Mu'amalat, on the other hand, mean acts of transactional dealing, covering such acts as sales, marriages, and partnerships. The rules of mu'amalat are enforceable by the state through the process, the judicial process, and therefore they are legal rules on the same footing as any rules of the laws of our Western countries. The fundamental difference between Islamic law and the laws of Western countries is a philosophical one, relating to the role of morality in the legislative process. In the West, there is no direct correlation between law and morality. A human act may be legally valid, but morally dubious. The law in the West acquires its legitimacy from its issuance by the legislative authority of the state, be it in absolute monarchy, as in England at the time of the Magna Carta, or a parliament or Congress, as in most countries today. As Justice Robert Jackson observed more than 60 years ago, one may be, at the same time, a law-abiding citizen and a thoroughly shabby character. In Islam, morality and law are intertwined. For human acts to be legally valid, they must be morally sanctioned. Acts mandated by the legal rules must be good, and acts forbidden by the legal rules must be bad. Muslim scholars agree that God, the originator and master of this world, is the one who assigns moral value to human acts and is the source of all powers, including the power to legislate. While the Prophet Muhammad, in his dual capacity as prophet and political leader of the first Islamic state, exercised legislative authority by reforming the existing law, he never claimed this power to be his. He attributed this power to God. It was God who was making the law, and the Prophet was the one implementing it. After the death of the Prophet Muhammad, believed by Muslims to be the last among all the prophets, direct communication between God and humanity ended forever. The question Muslim scholars were faced with was how to elaborate the law without a mediating prophet acting between God and humanity. Could the human reason discern the moral value of human acts and formulate the legal rules accordingly without divine help or assistance? The various schools of Islamic law engaged in a vigorous debate on this question. The minority schools, most prominent among them Al-Mu'tazila, answered this question in the affirmative. In their view, the human reason is capable by its own cognizance and without outside help of differentiating between good and bad. They argued that the goodness and badness of human acts are intrinsic values knowable to the human mind in one of two ways. Either intuitively, when the value of the act is self-evident, such as the goodness of saving a person who is drowning, or through discursive reasoning, such as when the mind concludes that telling a lie to save someone's life is good. The majority school, on the other hand, that came to represent Islamic orthodoxy, agreed that the human reason is capable of differentiating between good and bad, but this differentiation, in their view, is relative, subjective, and changeable with changing circumstances. In his book Al-Mustafa min Ilm al-Usul, Imam Muhammad Abu Hamid al-Ghazali, the renowned 11th century Muslim scholar, illustrates this point by giving the example of killing a great king. He says, this act of killing is considered good when looked at by the king's enemies, and bad when looked at by the king's loyalists. The consensus that arose out of this debate resulted in a determination that the ability of human reason to discern the value of human acts is uncertain, unreliable, and not trustworthy, and that human reason cannot be relied upon as an independent originator of the legal rules. The law must, therefore, be ascertained through divine evidence or proof. While human reason was rejected as an originator of the law, it was trusted to investigate the divine evidence, assess its meaning, and formulate its rules. The work of human reason in this respect is considered the most noble among all disciplines, religious or otherwise. As Imam al-Ghazali stated in his book, the fiqh is the most noble of all sciences because it provides the knowledge where reason and revelation come together and where opinion and sharia interact. The main task of the scholars of roots or usul of the law was to identify the sources of the divine evidence and establish a process by which the scholars of branches of law or furu' extract the legal rules based on that evidence coming from God. The first source of this divine evidence is the Quran, the holy book of Islam. Muslims believe the Quran to be the literal word of God, revealed to the Prophet Muhammad in a unique literary beauty and style, constituting a miracle that cannot be duplicated. Muslims further believe that the Sharia, as revealed in the Quran, is most perfect and complete and has answers to whatever problems human beings are faced with. In the Quran, God says to the Prophet, وَنَزَّلْنَا عَلَيْكَ الْكِتَابَ لِكُلِّ شَيْءٍ تَبْيَانًا لِكُلِّ شَيْءٍ وَهُدًى وَرَحْمَةً وَبُشْرًا لِلْمُسْلِمِينَ, which mean, and we sent down the book to you, explaining everything, and a guide, mercy, and glad tidings to Muslims. In his book Al-Risala, Imam Muhammad ibn Idris al-Shafi'i, the founder of one of the schools of Islamic law, a school named after him, says, no calamity will ever descend on any of the followers of God's religion without having a response to it in the Quran. The Quran is divided into 114 chapters, each with a number of verses addressing different subject matters. The least numerous among these verses are those pertaining to law. The second source of the divine proof is the hadith. Hadith means oral transmission or narrative and refers to the recorded reports of the Sunnah, that is, the Sunnah, the deeds and sayings of the Prophet during his lifetime. Muslims believe what the Prophet did or said explicitly or implicitly was inspired by God and constitute a source of divine proof equal in its probative value to the revelation in the Quran. The third source of the divine proof is the ijma' or consensus of the Muslim community. The justification for accepting ijma' as a source of law is based on a number of pronouncements in the other two sources. In his book Al-Mustafa, Imam al-Ghazali cites several verses of the Quran and a number of pronouncements of the hadith to justify establishing ijma' as a source of law. The strongest evidence cited by al-Ghazali is a pronouncement by the Prophet in which he declares, "My community will never coalesce on an error." There is disagreement on whether ijma' is the consensus of the Muslim community as a whole or of the scholars of a particular time. There is also disagreement on how to determine that all scholars of a particular time have agreed on a particular subject matter, and on whether a later ijma' can abrogate an earlier one. We do not need, however, to delve into such a discussion at this time. Ijtihad. The most important part of the science of fiqh is the process used by the scholars of furu' or branches of law to extract the legal rules from their respective divine evidence or proof. This process is called ijtihad, meaning the exertion of utmost efforts to discern the moral value of human acts and extract therefrom the corresponding legal rules. For this purpose, human acts are classified on a religious scale into three categories: good acts, or acts that God requests their performance; bad acts, or acts that God requests their non-performance; and the neutral acts, or acts that God neither requests their performance nor non-performance. They are permitted acts left to the decision of the believer. Good acts and bad acts are further classified on a legal scale into obligatory acts whose performance is mandatory, encouraged acts whose performance is desirable but not mandated, forbidden acts whose performance is prohibited, and discouraged acts whose performance is objectionable but not prescribed. If a pronouncement of the Quran or Hadith is clear and definite, in classifying a particular act as obligatory or forbidden, and in spelling out the legal consequences of non-compliance, the corresponding legal rules may be self-evident and require no further inquiry. But this is very seldom the case. In most instances, Muslim scholars have to exhaust all possible efforts to extract the legal rules through either interpretation or qiyas. The extraction of legal rules from corresponding divine evidence requires a full understanding of the meaning contained therein. The role of interpretation is to ascertain the intended meaning of the divine evidence, whether expressed by words, by actions, or by tacit approval. Muslim scholars have to spare no efforts whatsoever in this endeavor. They have to inquire into the explicit grammatical meaning of a pronouncement, its implicit references, and its implied inferences, and to make sure that all meanings intended by the divine will have been uncovered and formulated into relevant corresponding legal rules. The scholars of usul, or roots of understanding, have provided a detailed explanation on how the interpretation process works and what are its scope and limitation. Now, qiyas. The pronouncement of the Quran and Hadith provide divine evidence to a limited number of human acts from which the legal rules can be extracted. But how should scholars extract legal rules for acts not mentioned in the divine sources? Muslim scholars resorted to a process called qiyas, or analogy, to address this issue. Pursuant to this process, a legal rule extracted from divine evidence applicable to a specific act is extended to apply to another act for which no such evidence exists. The justification for the extension of the legal rule from one act to another is the commonality of the illah, or cause, between the two acts. For example, we know from the divine evidence that the consumption of wine is forbidden by God in a clear pronouncement in the Quran. If we were able to know also from the divine evidence that the cause for forbidding the consumption of wine is its intoxicating effect, then any substance with that property would be forbidden by qiyas as well. Most scholars have considered qiyas an additional source of divine evidence rather than a mere process for formulating the legal rules. Now, Muslim scholars admit that despite all the efforts exerted by those who practice ijtihad, we call them mujtahids, the understanding of the meaning conveyed by the divine evidence may not always reach an absolute certainty as to what God really intended. In such instances, a legal rule formulated by one qualified mujtahid may be different from the rule formulated by another qualified mujtahid regarding the same subject matter. In order to resolve this dichotomy, Muslim scholars adopted a policy under which legal rules arrived at through interpretation or qiyas by qualified mujtahids are to be considered equally valid, even if they were contradictory to each other. This situation is reflected in the different variation of legal rules that exist among and within each of the various Islamic schools of law. Now we get to the approach of Sharia to contemporary legal issues. Theoretically, the approach of Sharia to new legal issues is for the mujtahids to address the relevant issues through the process of ijtihad. Practically, however, this approach is no longer available for two reasons. First, the schools of Islamic law have ceased to exist as active centers for legal study, where Sharia law is elaborated. And second, the process of ijtihad effectively ended a long time ago when Muslim scholars refrained from conducting new inquiries into the original sources of the law, namely the Quran and the Hadith, and confined themselves to the practice of taqlid. How much? Okay. Okay. Now, taqlid, or imitation, can be defined as acceptance by later scholars of opinions already expressed by earlier mujtahids without going back to interpret or assess the divine evidence of the Quran and Hadith. As a result, a situation similar to an extreme form of a stare decisis policy emerged. and made it almost impossible for Muslim scholars to deviate from past formulations of the legal rules, even though Islamic law never considered this closing of the door of ijtihad to be legally binding or to even exist. Abu Hanifa, the founder of the Hanafi school, which has the most followers among Sunni Muslims, is quoted to have said, and I am paraphrasing here, what we have expressed, this is Abu Hanifa saying, what we have expressed is the best opinion we were able to formulate. Whoever comes up with a better formulation, his opinion should be preferred to ours. Now, let me talk about some of the practices in the Muslim world today that are contrary to Sharia rules. Sharia law was built on a sound legal principles and is still generally a good law. In his book, A History of Islamic Law, published in London in 1964, Professor Noel Coulson explains that most of the principles, and this is his words, underlying civilized society are reflected in Islamic legislation. This is not a Muslim scholar who is saying that. This is an English professor of law who is explaining what the Sharia law is. Now, the closing of the door of inquiry or ijtihad and the disappearance of the traditional schools of Islamic law left a void in the Muslim world that allowed rulers and governments to abuse Sharia law by attributing to it many practices that are not only inconsistent with its values, but also contradictory to its rules. In the name of Sharia, governments of some Muslim countries have, for example, put restrictions on the freedom of non-Muslims to express their own religious beliefs. They prohibited women from attending schools and criminalized the non-observance of certain acts of ibadat. Now, these practices carried out in the name of Sharia are contrary to the rules established by Sharia itself. The same thing can be said about imposing on women the legal duty of wearing the veil against their own will and volition. And probably some of you will be surprised to hear that. But this is again contrary to the established rules of Sharia. It is true that Islam preaches modesty in the way women dress, but Sharia law never made this a legal requirement to be enforced under the threat of physical punishment in this world. Women's status under Sharia as a case study. The objective of Sharia law as developed in the various schools of Islamic law has been to improve women's rights and protection. According to Professor Coulson, and this is, I'm quoting him, rules on marriage and divorce are numerous and varied in the Quran and represent some of the most radical reforms of the Arabian customary law. Now, under Sharia, women have full legal capacity to own, manage, and dispose of properties, to be involved in trade and commerce, and to work in any profession they might choose. Women have full capacity also to negotiate, decide, and enter into contracts on whatever condition they deem acceptable to them. These rules are still good law and meet the highest standards of any legal system, including standards of modern constitutional and human rights laws. But other rules are inconsistent. There are other rules which are inconsistent with the present-day equality standards, such as the rules on polygamy, the husband's authority to divorce his wife at will, and the prohibition against Muslim women marrying non-Muslim men. Now, the Sharia itself provides the mechanism to change some of these rules. By Sharia, you can change some of these rules. How? For example, under Sharia law, the wife has full authority to request, as a condition of her consent to the marriage contract, that the marital relationship be monogamous, that she has the right to divorce her husband at will, or that she has whatever rights or freedoms she wants in the contract. It has been reported that the Caliph al-Mansur made a promise to his wife not to marry another woman besides her. Apparently, he changed his mind after that. When he later solicited legal advice on how to be released from the obligation of his promise, he was not able to obtain any. Other issues, however, such as the right of Muslim women to marry a non-Muslim man, may not be resolved without reopening the door of ijtihad, which I don't think it is in the offing to reopen the door of ijtihad. But according to Hassan al-Turabi, the known Sudanese scholars and politician, a number of Sharia rules relating to women, including restriction against Muslim women marrying non-Muslim men, are not, in his opinion, consistent with Sharia and need to be changed. Now, based on my understanding of Sharia law, based on my understanding of Sharia law, it is reasonable to suggest to you that if we, scholars, academicians, and policymakers in the West, are interested in influencing the status quo in the Muslim world, there is much to be gained by suggesting to Muslim governments and rulers that they, first, eliminate practices contradictory to Sharia, and second, comply with such Sharia values as supremacy of justice and the implementation of the rule of law. Let me conclude by reading to you a story illustrating such values that was told by the Reverend J.L. Porter in his book, 5 Years in Damascus, published in London in 1855, when he visited the town of Busra in Syria more than 150 years ago. And apparently we had this book in Mary Jane's collection. This is what he said, Reverend Porter. As we proceeded in the town of Busra, as we proceeded, our guide pointed out on the left an ornamented doorway leading into a ruinous house called Bayt al-Yahudi, which means the house of the Jew. The tradition of which is as follows. The governor of Busra in the early days of Islam wished to found a mosque, to build a mosque. And the site selected was occupied by the house of a certain Jew. He was ordered to give up his property, but refused. His house was consequently pulled down and the mosque built. The Jew, however, repaired to Medina, meaning went to Medina, and requested an audience of the Caliph. He was directed to the tombs without walls, and there he found Umar, the Khalifa Umar ibn al-Khattab, clothed in rags, wandering through the cemetery. Upon making his complaint, the just Caliph made no reply, but demanded ink and paper. The Jew had no paper, and Umar, taking the jawbone of an ass, wrote upon it these words: "Pull down the mosque and rebuild the Jew's house." Delivering this to the supplicant, he resumed his walk. The Jew returned. The Caliph was obeyed, and the ruins of the house are still pointed out. Thank you very much.
Issam, thank you very much. Well, we now know of a just Caliph. I'm going to ask Issam later about how we open the door of ijtihad, because that's important. Our second and final speaker is Rabbi Shlomo Yaffe. You want to stand too?
If you don't mind, yeah, please have a Thank you very much. Quite amazing, worth coming absolutely for that presentation. I could spend a lot of time interpreting that particular story because a lot of biblical resonances to the jawbone of an ass, and it's always connected with justice, one way or another. But that being said, I'm going to do something a little bit different. Me and Issam spoke at the beginning that we would look at different topics and approach a different way. A lot of the things Issam spoke about, by the way, certainly in terms of the various components of Sharia and the like, certainly also exist in Halakha, which is the general term for the process of Judaic law as a whole. As a matter of fact, it wouldn't be surprising since the system was well known throughout the Near and Middle East and goes back several thousand years. What I'm going to do is I'm going to take us through a contemporary contentious topic, which is the issue of abortion. I am going to look at how Judaic law looks at it, how it has looked at it, and I'm hoping that this will be an appetizer, as if it were, to further explore this discipline, because in 30 minutes we can't do a lot, but I think you'll get an idea of how Judaic law works. Quite simply, there's a scripture, and that's what you have up there. You have the Pentateuch, the prophets, and the holy writings. That scripture cannot be contradicted, but must be interpreted. The process of interpretation and interpretation of the interpretations is going on now. The process is open. There is an idea of closing that, for example, a little bit further down, you'll see a statement, the Mishnah, which is a redaction of the law that took place in the 3rd century. So something that's unanimous in the Mishnah we do not contradict, but it can be interpreted, or we can even claim pressing need and the like. There is so much to say. Essentially, the main point of Judaic law is as follows, is that irrespective of the issue of whether God continues to communicate with humanity or not, God said quite clearly, and again, I am speaking from the perspective of what Judaism says about itself. We'll leave all the theological debates about dating and about revelation for other places and other times. Here, I'm going to let Jewish law speak with its own voice. And at the end of Deuteronomy, before Moses dies, God says, these words are not in the heavens. They're not across the sea. They're for you. They're in front of you. And from this we understand that even were a prophet to appear, and even if God were to speak to that prophet and say, change a law or interpret the law a certain way, we say, go away. God himself has chosen to have no more influence on the law. Only the text and its system of interpretation can be utilized, and only human beings using the system of interpretation, staying loyal to those things that are immutable, can continue to interpret the law. So the interpretation of the law continues to this day, and there is and God himself, as if it were, has forbade himself from any involvement. So prophets, revelations, dreams, none of this has any meaning. Only rigorous intellectual interpretation of the law with the understanding that its primary structures are immutable because they are divine in origin, which is what is the classic Jewish belief. So what I have over here, basically, this is a quick vision of the texts that form Jewish law, and I'm going to go to the next pages to show you just an idea of where these texts come from. So you of course have the land of Israel, which was before known as the land of Canaan. This is where most of the Bible is formed, but the only books of the Bible which have legal power are the 5 books of Moses. All other books can only tell us what people did. The 5 books of Moses are the only scriptural source of authority, though there's an oral tradition, as we'll see. Those, of course, were given in the desert. Then you have the activity of study stays in the land of Israel until the Jewish people are exiled. The people of Israel, only called Jews in the Persian Empire, they're exiled to Mesopotamia, and basically southern Mesopotamia. You see on the map where it says Babylon, and you see where the Tigris and Euphrates come really close to each other. So that section of Mesopotamia is not just where the Jews spent 70 years of exile before many, though not all, returned to the land of Israel, but in the 5th century BC or so. But more importantly, after the destruction of the Second Temple by the Romans, this became the cockpit of Jewish intellectual life. The Babylonian Talmud, which we'll meet later, which is the key source of Jewish law to this day for very good reasons, because of its scope and many other things. So it remains it was created in this region of what's now southern Iraq, and as well as earlier texts also are profoundly influenced by this area. Only after about the 11th century does the center of intellectual life move to North Africa, to Spain, to Europe, and so on. But basically, for at least from about the year 300 to the year 1100 or 1050, the center of all legal authority was mostly what was established by what's known as the Shtei HaYeshivot, the two great authorities in Mesopotamia. That's just a little bit of history. Now, this is a partial course of tradition. I actually could start with my teacher, and if you had time, I could go back person to person, real biological living person, to Moses. I could do it. And I know who these people are, and each one the teacher told the teacher before him. I'm not going to do that. Here's a partial course of tradition. So, and by the way, the BCE dates, the correlation of Judaic dates and the standard academic dates are a matter which only the bravest tread in, and they tend to fall to. It's very complicated. What I have discovered is that you have about a 450-year fuzziness when you start with Abraham, and at Alexander the Great, you get exact year-to-year correlations. But that's for another time. At any rate, so roughly, the Jewish year 2448, 1312 BC, Moses receives the Torah on Sinai. He is taught the 5 books of Moses, as well as the oral tradition, which I'll introduce in a moment, go to about 1272 BCE. And here are just names that you may be familiar with, but this is the tradition of the transmission of the law and its interpretation. We'll see what that includes in a moment. So you have Samuel, Elijah, Jeremiah at the destruction of the first temple. Baruch, the son of Neriah, is in the first exile in Mesopotamia. Ezra and his court, very significant group known as the Great Assembly. These people actually structure Judaic law as we know it, introduced the entire realm of prayer services and the like, which did not exist in a formal means. It's interesting to note that the synagogue, which many people, Jewish or not, associate with Judaism, is the newest and, shall we say, most originally created out of whole cloth part of Judaism there is. And it's the laws about how you do business and how one speaks about another person or personal beliefs about God or about other human beings. You know, statements like "Don't hate your brother in your heart," or the idea of seeing goodness even in tough things. These are really core Jewish laws. Most of the appurtenances that we associate with services and synagogue and all that are relatively new and relatively peripheral, because Judaism is very much, as Isa mentioned, about law, about practice. Then you get, so here you go through this is the period of the Second Temple. In the land of Israel, Simon the Just, Hillel and Shammai, who are the first people who begin to form the text, though the laws that existed before are known as the Mishnah. And then you get to Rabbi Judah the Prince, the redactor of the Mishnah. He was born about 150. The Mishnah was redacted. There was no printing. But the Mishnah is a statement of the core law, the core Jewish laws, the core laws of Judaism as they have been transmitted, developed, and discussed for the previous 1,500 years. And the Mishnah is extremely concise, but it represents the first written statement of Judaic law. It had been oral until then. And now just running through a bit of history. So Abaye and Rava are two of the very significant figures of the Talmud, about 325, 350 of the Common Era. The Talmud is completed about the year 500, probably. Now, the Talmud is basically the discussion of the core statements of the Mishnah. How did you get there? What do you do in a different situation? How do you deal with contradictory statements? How do you resolve arguments? How do we deal with this is very important, how we deal with a situation where the letter of the law contradicts the moral and spiritual values that we know the law wants us to uphold. This is crucial, and we'll see this a little bit in our discussion in our discussion today. Then you have Rav Hai Gaon, was the last of the great rabbis of Mesopotamia, located in Baghdad. Afterwards, the Baghdad Academy declined in importance, which, by the way, is not inconsistent with what happened to Baghdad in general. It declined until the Mongol sack, at which it sort of disappeared and reappeared only many hundreds of years later as a significant center. You have Maimonides, the greatest figure probably since Rabbi Judah the Prince, the great polymath, the author of the Guide to the Perplexed. And with Maimonides, you have a tremendous intersection of the world that Professor Saliba was talking about and we're speaking about. Then you have the Code of Jewish Law, Shulchan Aruch, by Joseph Caro. He was expelled from Spain. This is approximately 1550 or so. It is 1550. And someone who will quote later, you have 1959, you have Igrat Moshe, Rabbi Moses Feinstein, is someone who really introduced and applied Talmudic principles to issues like organ transplants and a lot of bankruptcy, corporate law, and a lot of modern issues. So, and the point of this exercise was simply to take you through this chain to understand that this is an ongoing discussion. Very briefly, if you go to a traditional Jewish school where the kids study Talmud, whatever language it is, whether it's in Hebrew or in Yiddish or even in English, they don't say Abaya said. Abaya and Rava are the great central figures of the Talmud. You don't say Abaya said. You don't say Rava said. You say Zokta Abaya, Zokta Rava. Abaya is saying, Rava is saying, because in the Judaic legal system, we see ourselves in a constant dialogue and conversation and argument with everyone from the beginning, from Moses to our time. Okay, so here you have this, here you have it larger on the screen. You have the Mishnah, which is all the sections of Jewish law. And from the Talmud is the last work which had representation from all the Jewish communities in the world. All other works are local. The Sephardic, in other words, North African and Spanish, the European, and so on. You have first editions of many of these books here at the library, by the way. And essentially, all these works you see over here, from Rambam, which is Maimonides, through the Torah and the Shulchan Aruch, are redactions of Jewish law systematically by subject, which had not been done till then, which opened up a whole new area of discussion because Jewish law was now organized at a proper taxonomy and so on. And now let's go to an actual real case. Now, just what's the source of all this? So all the commandments, this is from Maimonides' introduction to Mishnah Torah, which is the first organized, coherent, rather than discussion, but actual cataloging of the law of Judaic law, the first genuine code. So this is the circa 1177. So all the commandments that were given to Moses at Sinai were given with their interpretation. As it's written, I will give you the tablets of stone, the law and the commandment. And the law is the written law. But again, important point. If you take the text of the 5 books of Moses and try to live by it, what you do will not be Judaism. The actual translation of the 5 books of Moses tell us nothing. It is the table of contents and perhaps a key to the law. Without the oral law, it's useless. Jewish law is not biblical law. It's the written law. The commandment is the interpretation. We're commanded to fulfill the law according to the commandment, which means to say, so for example, it's often said, well, at some point the Jews modified lex talionis, an eye for an eye. Not true. Never ever in any Jewish court was there ever an eye for an eye. It was never understood that way, and time doesn't allow, but the exegesis demands that it not be understood that way for all kinds of reasons. I could have done that, but lex talionis is not on the Supreme Court's docket. I wanted to talk about things that were more contemporary. Thank God we've gotten beyond that. But the point is that someone wrote a very funny book called The Year of Living Biblically. Maybe some of you have seen it. It's funny to me because that's exactly what happens when you try to live by the text without any interpretation. It's meaningless. And more importantly, in Judaic law, the oral tradition and the written tradition, the oral tradition are the systems of interpretation. not everything that we have to this day. But those systems of interpretation and those ideas that are handed down as being the ideals behind the law are as central as the written law. There's two texts, one written, one oral, the oral redacted, finally written down in the period of the Mishnah in the 3rd century. One is not important, more important than the other. So in other words, you don't have this idea where someone will say that 5 books of Moses is more central and we can't go beyond that. The groups that said that, like the Karaites, were considered by mainstream Jews as heretics. The idea that God gave a law and it's not subject to interpretation, elaboration, and added institutions as needed to make the law carry out its spirit, the idea that it's rigid and cannot be interpreted is considered the greatest possible heresy in Judaism. Here we discuss this idea that he writes about how the Mishnah was written down. Why did he write them? Was the Mishnah written down? Again, the first statement of Jewish law, though it's not exactly a code, it's more a list of laws. The reason for this is essentially because the Jewish people had been scattered throughout the world, and without a text, he realized that the law would not be able to be dealt with. I'm happy to send anyone who wants the entire thing. I want to get to the main point. Now, here is a law, and now I'm going to spend a few minutes on how this law is interpreted through the ages. Again, this is only a very brief trip through an incredibly profound and huge legal system, which is every bit as complex as the one we have in this country. And therefore, I'm going to take you a little bit through the development of the laws pertaining to abortion. Now, let me begin by saying that safe, consistently successful, if you can use that word, abortions, were only possible really in the 19th century. Though there's discussion 16th, 17th, 18th century, but the real discussion as a matter of public policy and moral choices that individual women would habitually have to make is something that comes about only in the 19th century. But there's a source. Now, this law could be straight out of the Code of Hammurabi. One of the differences is that the written law was always subject to the oral law. So the oral law asks not what does this text say, but what does its mean? What is its idea? What is its justice? So the statement is as follows. Should men quarrel and hit a pregnant woman and she miscarries, there's no fatality. He shall surely be punished, which is monetary punishment, when the woman's husband make demands of him, and he shall give restitution according to the judge's orders. By the way, just for those who are concerned about this is besides the restitution that has to be made to the woman, as in any case of personal tort, and that's her money, not his, because women have absolute rights to their own money. But there is also something, even though the husband wasn't carrying the baby, but the fact is, because he lost something, he gets something too. Again, this is just for the record. It's not a negation of the woman's rights. It's saying that husbands also have rights in their babies. At any rate, the idea of there being no fatality is, there's a whole discussion, but the ruling in the Talmud, the way the Talmud finally agrees to understand this piece is that if I aim a gun, there's an arrow there, but let's say I aim a gun at someone and I want to kill them, and someone else who I didn't want to kill runs into the field and fire gets killed. So the ruling is that because you had premeditation and you've been warned and you intended to murder, you're liable for murder. So even though you wanted to hit someone else and you hit this woman, since you wanted to kill and you killed, you're liable. But if there is no fatality, then he's punished, and that means there's a payment in addition to the payments to her for the loss of the fetus. So from this we see what? Quite simply, that the death of a fetus is not considered murder. Because if the woman was killed, he would be guilty of a capital crime. But with the fetus, he pays money. So it's clear, first of all, that whatever the rights or whatever our obligations, because Judaism speaks less about rights than a mutual network of obligations, whatever obligations to the fetus is, it's not murder. Now, this doesn't mean that abortion's permitted. It just means that there's a difference. Now, the classic litmus test for the real hardcore proponents and opponents of abortion. This is a very tough Mishnah to read, But if a woman is in hard travail, this is before C-sections were safe, one cuts up the child in her womb and brings it forth member by member, because her life becomes before that of the child. But if the greater part is proceeded forth, which includes the head, and he's breathing on his own already, or she is, one may not touch it, for one may not set aside one person's life for that of another. So the basic point is, you can't set aside one person's life for another once a child is already breathing on their own. As long as they're a fetus, even in the 9th month, the mother's life comes first, because her life, she has the right to her life, even at the expense of the fetus's life. There are different interpretations of this which affect the law, but this is the statement. Now, in the Babylonian Talmud, again, this text we mentioned, that is a text by committee, reached its final form probably about 600. Nazir, page 51. All the Talmud always goes by pages. That's how it's done. All the editions have the same pages or marks to the original pages. The fetus counts as the thigh of the mother. In other words, now this is in reference to the idea, a complex and arcane idea about ritual purity and impurity. But the point is that a fetus is considered a limb of the mother. What does this mean? Again, the Talmudic law is not concerned with the bald statement, it's concerned with the idea behind it. The idea behind it, it says, is that, well, you would amputate a fetus when you would amputate a leg. You can't just go around, you don't have a right over your own body. Your body's given to you by trust by God. You don't go around cutting off people's legs unless their life is in danger or some pressing reason. So the same would apply for a fetus. So a fetus has a certain integrity as part of the mother, but not as an independent human being. Now, we'll see soon under what circumstances does this justify the amputation, as if it were, of a fetus. And we'll also see why Judaic law sees the fetus as something that is not entirely its own life. Now, important ruling. In Yevamot it says, another tractate, until 40 days from gestation, the fetus is considered mere water. Now, of course, it's an arbitrary number, but we know this by exegesis. But there's this idea that for the first 40 days, it doesn't even have the legal status of a fetus. So, for example, in cases of, let us say, some congenital disability that is very severe, where authorities who say, well, you can't just kill this potential child after 40 days, would permit an abortion before 40 days. Not all see this as the case. But again, we are concerned with the implication. And by the way, just very briefly, the theological idea over here is that biological life is not the same. The fact that something is physically alive and even has physical reactions doesn't yet mean that it has that soul, that image of God, that makes it an independent human being. And there's a difference between the cells being alive biologically and someone being a legal human being, which is also a spiritual human being. And this is where Judaic law manages to fall afoul of all the sides of this debate. Neither the pro-life or pro-choice camps particularly like this approach. But there's a difference in Judaic law between and this is all extracted and extrapolated from these very narrow statements in the Talmud, ritual purity and impurity, about torts and the like. But if you ask, what is the concept here, and what is its moral implications? And the idea is always stronger than the form. In Talmudic law, we're always taking the idea and forming law out of the idea. So as technology and society change, and as certain things don't change. No matter how you slice it, certain things will not change. No matter how much agriculture changes and animal husbandry changes and the like, the fact is that Judaic law will never permit Wilbur as a meal, and that's it from Charlotte's Web. That's it. That will never change. But other things, not that they change, but these laws that were just narrow ideas all of a sudden explode into significant ideas. And when we talk about artificial intelligence at the very end, we'll get to that. Okay, now, Torah Chesed, 1870. Now abortion is possible. It's possible to do abortion relatively safely. Schneur Zalman of Lublin a very significant legal authority, a masterful piece, responsum number 42, goes through every possible variation of the abortion issue, but he paraphrases a statement from Tosafot, which are glosses on the Talmud from 1320 from Western France. Since the fetus's life, Eastern France, since the fetus's life is entirely dependent on the mother, it has no independent legal existence. That's the issue. It has no life without the mother, and therefore it has no independent legal existence. So therefore, Torres Chesed goes on to argue that any health benefit, as long as it's a severe disability, is sufficient reason for permitting abortion. So you don't need to prove danger to the mother's life, because it has no existence independent of the mother's life, and where the mother's health will be seriously compromised. Later authorities in the 1930s apply that to mental health also. But again, here the default is you never chop off people's legs without a good reason, and we never destroy a potential life without a good reason. But where there is a reason that is compelling for the mother, most, though not all authorities, there is a more conservative stream of interpretation that only allows where the mother's life is in danger. But in Jewish law, this is the minority opinion. Rebbe Lezer Waldenberg, writing in about 1965, great suffering is sufficient reason. He quotes an earlier 18th century German authority, the Chavot Yair, that abortion is a grave sin if there's no pressing maternal need, because you're destroying a potential human being. So economic reasons are not considered sufficient because it's the community's job to support and give childcare. Economic reasons are never ever a reason, because the community has a obligation to support any child and any member of it, and we look at Jewish law through this context. However, there are those contemporary authorities who demand endangered mother's survival to be proven. This, like I say, is a strong opinion, but a minority one. Okay, very quickly, we have 2 minutes left. I want to give you a quick organ transplants did not exist until the middle of the 20th century. What are the concerns with organ transplants? Well, triage, who you give the organs to, and the donor. Because obviously you want to fresh an organ as possible, becomes the issue of brain death. What kind of brain death? Do we want autonomous cessation of heartbeat? So biblical do not murder applies to all cases, even if a victim is dying. A human life is of absolute value. Show me a senile person who has 5 minutes to live, you kill them, it's the same as killing the most brilliant young doctor who's 20 years old, because human life is of absolute value. And going back to the earlier site about the baby who's already born, we do not push away a life for a life, as earlier. So therefore, we cannot hasten what Jewish law considers autonomous death for the sake of saving some young person who needs the organ, even if the organ will deteriorate. However, even though Jewish law is very big, as many of you may know, about burying people as they are, without any change, without any autopsy or embalming and so on, all prohibitions except murder are waived for saving a life, including to the dust you shall return. So here you have something that isn't relevant till 1930 or 1940, but the Talmud's understanding of biblical law, as you saw developed during abortion, immediately enables us to deal with it right away, because again, the Talmud says, look at the essence of the idea and bring it into wherever your time is, because the process of interpretation and creation, always in reference to what came earlier, but this creative process, this partnership between the immutable Word of God and the understanding of the human beings. I should point out to you very briefly that there's a great line about this from the Lubavitcher Rebbe, who was my mentor and whose yahrzeit, the anniversary of his passing, we mark soon, made the point that it's not just that God let people interpret the law, but that God designed the human mind. So whatever interpretation we come up with, using our minds independently, but in reference to the system of interpretation, that human understanding is God's understanding, and it's not that God lets us interpret, it's that the human and God become one by this interpretative process. God desires to be our partner and to be one with us, and to do that we must have this independent process of mind within the parameters as defined, as you see in today. Killing someone who's legally alive is never permitted. ranking recipients is permitted for those presently ill, but not on an actuarial basis. In other words, you can give the kidney to the person most likely to survive, but you cannot say there is statistically someone else coming up and ignore a sick person in front of us. As it stands, okay, now, cloning and genetic engineering, as it stands presently, it would be permitted to clone a human being to save the life of a living human being, because all concerns are trumped to save a life, but for enhancement purposes, never. Last of all, human function is the arbiter of humanity, not appearance. Hell from 2001 was human according to the Jerusalem Talmud. Rabbi Yassa stated in the name of Rabbi Yochanan, if a creature has a human body, this is hypothetical. By the way, one thing, there's a lot of things in the Talmud that people used to laugh at. The Talmud engages in thought experiments, knowing that if human beings can think of something, it's likely to happen. The Talmud hypotheses a flying iron box. Well, that's how a lot of us got here today, right? But the Talmud hypotheses it. But if the human mind can think of it, it can invent it. So if a creature has an animal body, but its face is human, it's human. So the Gemara asks Rabbi Yassa, yet suppose it's entirely human, but its face is animal-like and it's learning Torah. It looks like an animal, it looks like a sheep, but it's capable of this interpretive process. It's capable of logical human reasoning. Of course it's a human being. Can one say, come and if it's entirely animal-like, but it's face human, it's plowing the field, do we say come and perform marriage and divorce? Of course not. But on the other hand, do we say we'll serve you for supper if you can think like a human being? Of course not. Because this ability this human ability of intellect is the essence of humanity. Make me a machine or a Hal or any other creature, a frog that can do this, it's human. And this idea wasn't even a technological whisper 2,000 years ago, 1,800 years ago when the statement was made. But again, the Talmud is concerned with getting to the essential truth of reality. Sometimes it takes 2,000 years of technology to catch up. Last of all, I want to say that the purpose of all of this, the reason why, we didn't have a chance to get into it properly, but why we look very carefully and demand that the law conform to the values and inherent in the Torah is because great is shalom. The Hebrew word shalom is translated peace, doesn't mean peace. It means wholeness. It means wholeness in the sense that all of the world, all of nature, all of ecology, all of humanity live in harmony with each other, which is why there's a great deal of concern in Judaic law for the rights of those who are outside the covenantal community. As articulated in the very first statement of international law ever, the universal Noahide law, which some of you may be familiar with. And as it says in Proverbs, her ways are the ways of pleasantness, all her paths are shalom, are whole. And this is Maimonides fittingly at the end of the laws of Hanukkah, that the goal of this entire process is to create harmony between God, humanity, nature, and all of those with each other. Thank you very much.
Halakah seems quite different from the common law. I wonder what John Roberts would say about some of it. I once had supper with Robert Bork, who is the originalist, and this is, of course, with respect to the Constitution, not the common law. And he said everything that was known at the time of the Constitution, that's set. But he acknowledged that as technology changed, the law might be in some way conformed, rather something the rabbi said. This was a very high-powered, vigorous discussion on both parts, and I hope that the questions will be equally so. And, if you have a question, I don't know whether there's a mic or not, but you can just speak loudly, get up, say who you are, and ask a question if you'd like to, and indicate to whom you'd like to ask it. And I'll just stand here and let you just proceed. This lady here, she was first. Is there a mic? Otherwise, just... Guess there's no mic.
I'll turn slightly so others can hear. Rabbi, this is primarily directed to you, but also to Professor. On this question of contemporary issues, healthcare is being debated very much today. And there's one issue, I like what you said very much about the last 5 minutes of a life not worth living, as some would say. You cannot take that life. But there's also a practice that has become very prominent to withdraw food and water. from a person. And some would argue, and I think it's pure sophistry, that you are not doing something to take a life, but you're really not doing something. Could you give us an assessment of that, from both standpoints?
I hope this mic is on. Could you see?
Is this on?
Yeah.
Yeah. Sometimes you can't tell with me if it's a mic or not a mic.
I don't think he needs one, but
I am the rabbi of a synagogue with a very large high sanctuary and a elderly community. So the main reason they hired me is because as a child I had a little mishap and swallowed a microphone. That being said, the issue you raise is one of the big discussions in Judaic law today, because people deal with it every day if they follow Jewish law. Essentially, it's okay not to stop the dying process, which means, for example, that we're giving someone a given medicine or a given operation, a given surgery, will only prolong their suffering to no change in the prognosis. You don't have to do that. But food and water you cannot withdraw. If the person is being fed, you can't withdraw the feeding. Whether you want to put someone through all the pain and the issues pertaining to inserting a feeding tube, that's a separate issue. You may not have to insert a feeding tube. Once food and water are being given, that cannot be withdrawn because that's an act of removing a basic need for life, same as respiration. In Judaic law, we always tend to ask very carefully in these end-of-life issues, do you want to do this in the first place? Because withdrawing something is very hard, even where it seems not that rational. But withdrawing food and water is a profound problem if there's a delivery means already set up and the like. Not giving medicine that only prolongs suffering and doesn't give any meaningful happy life is a separate issue entirely. But the bright line is food and water.
there was the lady in green.
Yeah.
Oh, I'm sorry, Assam. Forgive me. I thought it was.
Okay. I will take a different look from a Islamic standpoint, because as I mentioned, there is the legal scale and there is the religious scale. And the legal scale is a little bit different from the religious one. And here I am not really familiar or authority to speak for what is the religious scale in Islam. I just studied the Islamic law from a Western standpoint. What is just legal? So I cannot really address the scale of the religiosity on the question that you have raised, which is very important question, and I'm sure Islamic scholars on the religious side may have something to say about it.
Thank you, Assam. This lady.
My name is Teresa Papadimitriou.
And let me just say one thing, because Mary Jane wanted me to say that the person to whom the question is put should try to repeat the question for the purpose of the transcript. So, I'm sorry.
Okay. My name is Teresa Papadimitriou, and I'm a colleague of Sam, and I have a question for him. Can you please tell us briefly how the issue of abortion is dealt under Sharia law?
Yeah, the question is how abortion is dealt with under Sharia law. Under Sharia law, specifically, abortion is not allowed because it is considered a killing. So there is nothing in the law which, when I study and talk about Sharia law, I am talking about it from a Western standpoint. I am not getting into what the religious scale would talk or would say about these issues, which Rabbi, I think, has probably more to say about it, as he did.
I would just point out that in Judaic law, there's no distinction at all between religious and civil whatsoever, because there's this sense of a holistic vision, and in harmony with God and harmony with your fellow human being are one and the same thing. So there's absolutely no distinction, which is something which is a difference, I think.
It is different because the Islamic law was a system of law that has been applied in a society, in a state, so it has acquired the characteristics of what we call the positive law, or the law our Western society. And this is why when I started to say, when you say Sharia, many times people confuse Sharia with the Islamic law. And this is very important, I think, for us to understand. What is the difference between Sharia law per se from a Western standpoint and as a religious law, which again, I mean, they have, these issues have been discussed and there is a lot of literature about them.
Islam, let me ask you a question about that, about lawmaking in a Muslim country. As you say, you have the Quran, you have the Hadith. Now comes, say, the 19th century. I lived in Turkey where the Majella was the attempt to codify. If I am a lawmaker in a Muslim country today, in 2009, and an issue comes up which is addressed in the Quran and in the Hadith, but it's not addressed completely, I, as a lawmaker, what freedom do I have? Must I try to be as rigorously loyal to the exact words of the Quran and the Hadith or not? Or do I have to be rigorously loyal or not?
Well, I think as it develops, really you cannot go, anyone now is allowed to go back to the Quran or the Hadith and formulate the law. And this is why the whole question of the closing of Bab al-Ijtihad. They considered what has been written is the law, not what is in the Quran or in the Hadith. And in fact, when Britain was in India, they issued specific orders to the judiciary to tell them that when you have a question about Islamic law, you cannot go back to the sources. You have to go to the what you can call the books that explained what the law is.
I see.
And this is again the whole question of Bab al-Ijtihad or not. But one thing is important also to know that not all the schools of Islamic law are the same. You have some deviation from time to time into details. And within the same school, sometimes you have differences. And you can choose, pick and choose if you want. To take, for example, let us say in the Shia schools, a woman, a daughter, can have the whole inheritance for herself if there is no other children. Under the Sunni schools, this is not permitted. So within the Islamic law also you have some variation and some changes that can be made.
I saw lots of other hands. We'll just go.
Jewish law?
Yeah, that the daughter.
Yeah, there is probably a lot of things that are
We're
similar.
going to have many more questions than we have time, but the gentleman over there next, and then call me.
Thank you. I'm Jordan Pendergrass with the Beckett Fund. My question is, what if there, in either of your religious system, when there's a civil law that contradicts the obligation or the prohibition of your religious belief, what's the balance of responsibility regarding civil law?
Just repeat the question when you answer it. Either
You
of
wanna
first.
answer?
Yeah, go ahead.
Okay. The question is, when the civil law contradicts the religious law, what's the degree of responsibility? Actually, I should begin simply because the Jewish community has lived with this reality for the last 2,000 years, and this is actually one of the issues I think that the Muslim community is facing, is how to function as a minority in societies with different laws. There's been a lot of discussion and writing about this. In Judaic law, it's as follows. Here you do get a distinction. Monetary law, any law dealing with monetary or civil obligations, is modifiable by covenant. In other words, I can agree to accept, even though normally you need a document signed by two witnesses to establish liability, I can say I'll accept your bill as a liability. And the same thing is, even though Jewish law doesn't have bankruptcy, if you do business in a country where bankruptcy is a possibility, so the assumption is that you're accepting that. So because you're allowed to give away your money or your financial rights, so financial and civil issues do follow the law of the land. But when it comes to matters that have to do with your fundamental religious your obligations to God, or moral obligations, those are not fungible. So for example, there was a period of time where under the Soviet regime in the USSR, it was forbidden to have religious education. So there are people, including my wife's grandparents and great-grandparents' family, and some of them died, literally put their lives on the line to engage in religious study with children. Because that is not subject. That is something that you have to go to just about to the wall for. So if it's something about your obligation to God or a moral obligation to your fellow human being, that God's law stands above all civil law. If it's a monetary law, a civil law, something like obligation to serve on a jury, something like any monetary law, the obligation to serve in the armed forces of the country you live in when you're drafted and the like, all those we follow the civil law. There's much written about this, including a very groundbreaking book that came out in Israel in the mid-50s, but I hope this answers the question somewhat.
Isam?
With this, there is one thing I probably, it may not be directly answering your question, but I think very important. Under Islamic law, you may be doing something completely legal, but at the same time, in the next world, you are going to be paying a price. Let us say, for example, you have a debt that you owe, and from a legal standpoint, from the Islamic legal standpoint, there is no obligation on you. In other words, they cannot go to the judge or to the court and enforce you. But they are telling you, I mean, the Islamic law is telling you, you are going to pay the price if you know that this obligation is on you. It's not sufficient that the law has no claim against you in this world. If you really believe that you still owe this money, you have to pay it. But it's not, again, on the legal scale that the Islamic law has provided for this world. So there is two scale that always has to be present in the mind of the people who are following the Islamic law.
You know, this exists exactly in Jewish law. If someone took on an obligation to someone that the law cannot, it's not actionable in a court, the law cannot enforce it. Mm-hmm. So we allow the victim to stand up in public, in the synagogue or some other public space, and the community declares that though you are not liable in public, though usually we avoid shaming people in public, that he who took payment from the generation of the flood for being dishonest with each other will take payment from the person who doesn't keep his word, even though we can't. It's not actionable.
I'm glad we have more in common than
the moral is that debtors have to stay out of the temple. It's 2 o'clock, and although Hongja introduced me, it's Mary Jane who's in charge. How much more time do we have? Good, because there are a lot of questions. There was a gentleman, well, this gentleman had a question on, this gentleman in the white shirt.
I had a question for Dr. Saliba. You mentioned ways to get Muslim rulers to better implement Sharia law. There has been resistance among Sunnis, especially Wahhabi scholars, for codification of law. Do you think, and King Abdullah has contradicted that a little bit, do you believe we should have codification of Sharia law? Do you think that would help in reinterpretation?
You know, I don't
Repeat the question, Isam, please.
The question is whether it will be good things to pressure government or rulers to codify or change existing laws. My point really, I don't want to get into politics in that. What I am saying is there are certain rules of the Sharia law which we can go to the books and find them, read them, and know exactly what they are saying. Sharia law, for example, is very clear that if you are a Christian or a Muslim, you have the full right. It's not only that you are allowed, you have the right under these rules of Sharia, of Sharia law, to practice your own religious beliefs. So if somebody is coming and say, well, in the name of Islam, I am doing so and so, wouldn't be a good idea for us to say, let us forget about what all the problem that we have probably about cutting the hands of thieves, or why don't you apply the rules of the Sharia law that you are claiming to be applying? I mean, engage with them from the point of view of the Sharia law itself. And I think you will be doing a lot of good things that is not being done today.
I think Islam is being very polite. I had a friend, my brain is going, the General Counsel of the World Bank, Ibrahim, you know him.
Shahata.
Shihata, forgive me, yes. He's a wonderful man, and he wrote a lot on this subject. And it's those question of ishtihad, the bab ishtihad, the door closing. He said, darn it, he was less polite, the door should be pushed open. Too many Muslim legal scholars are, he said, intellectually lazy, L-A-Z-Y. If they did their work, this question of codification, wouldn't have to necessarily get to it. I think that's what Islam is saying. I think just a lot of
what
work
I'm
needs
saying
to be
is whether
done.
codification or not, you can tell these governments
Yeah.
that this is not what you are saying, that this is in the name of Islam. It's not according to the Sharia law. I'm not talking about religion. I'm talking about the law of Islam, which is called the Sharia law, has books, has been written, and you can go and say, what is the rules here? The rule is very clear. Let us just start by adjusting these places to what the Sharia laws, what the Sharia rules are.
Maybe let me have one more question. There were lots of people that hands up before. Well, we seem to. Do I?
The lady in the.
Oh, I'm sorry. Please, that lady. I didn't see you in the light.
I was curious, you clarified about the Sharia law. You have clarified that the modesty dress, for example, is not part of Sharia law. What
Modesty
about
is.
certain punishments, like stoning for adultery, for example, or
Hard punishment, as it's
Yeah,
called.
the question is, we talked about some issues that are not really, from a Sharia standpoint, required.
Could you repeat the question, please?
Yeah, but what about stoning, for example? That's true. I mean, this is a part of the Sharia law. It is in the Sharia law. But you cannot just talk about a legal system by bringing up one issue or two issues. There is a complete system, legal system in Islam. You have to look at it as a whole. Yes, there are a few things that are not in compliance with what we think the law should be.
Yes, let me ask you a question. Does the Sharia say you must stone a person? There's got to be witnesses, by the way, and it makes it fairly difficult to apply it. Does it say you must or that you may?
No. I mean, there is also another very important thing in these issues, that the Islamic law, if you repent, many of these crimes will go away. I mean, it's very difficult to, in 30 minutes, to give you really a comprehensive, but the point I am saying, yes, there are a few things that you can bring out and say, I'm criticizing. Europe now, they are criticizing us in the United States. Why? We are not complying with human rights. Why? Because we are still applying the
death penalty.
Does this mean that our system is not good, or our legal system? So,
well, we could obviously go on for a long time, but I think maybe we will now call this meeting to a close. Of course, I want to thank our speakers, and I think we want to thank the Law Library of the Library of Congress, and thank you all for coming. Thank you.
Thank you very much.
This has been a presentation of the Library of Congress. Visit us at loc.gov.